Once upon a time, there was a man named Carol. Carol had owned the row of shop lots in Bhutan for many years. He worked hard to buy them, and he took pride in every brick and wall. Every morning, he walked past the shops, checking for cracks, dirt, and anything out of place. To Carol, this property was more than land and buildings. It was his achievements, his security, and his identity. Anyone who crossed his boundaries, even a little, touched enough. One day, a new neighbor moved in next door. Her name was Ceci, a young entrepreneur full of energy and ambition. She had just opened a fast food restaurant called Fat Burger. She wanted her shop to stand out, especially in a busy commercial area. So she installed a huge, bright signboard that glowed day and night, hoping it would attract hungry customers from far away. But there was a problem. The signboard was too big. It didn't stop at a building line. Part of it extended into Carol's space. It hovered above his property, like it didn't care where the boundary was. The moment Carol noticed it, his mood changed. His chest tightened, his jaw clenched, and his passion disappeared. Instead of walking over to talk calmly, he reacted out of anger. He pulled out his phone and typed a harsh message. You have 24 hours to move that sign, or else. Ceci read the text while standing behind the counter. She frowned but shrugged it off. To her, the sign only crossed the boundary for a few inches. She felt Carol was overreacting. Business was hectic. Customers were coming in, and she had more important things to worry about. She decided to ignore the message and carry on with her day. The next day came and went. On Saturday morning, when the street was quiet and most shops were still closed, Carol had made up his mind. The sign was still there. To him, there was a clear sign of disrespect. He believed he had waited long enough. He climbed onto the roof with an industrial saw, determined to remove the part of the sign that crossed into his space. His heart was pounding, but not from fear, but from anger. As the saw bit into the metal, sparks flew. He didn't think about safety. He didn't think about consequences. Suddenly, everything went wrong. The moment the metal gave way, the entire 15-foot sign lost balance. With a deafening crash, it fell off the building and slammed onto the side below. The ground shook. The noise echoed through the street. Beneath the sign was Ceci delivery scooter, parked near the shop. In seconds, it was completely crushed. Just then, Ceci arrived forward. She froze. The sign was destroyed. The scooter was flattened, and Carol was standing there, saw still in his hands. Shock quickly turned into anger. She screamed out at him, demanding to know what he had done. Carol didn't calm down. Instead, he raised the saw and pointed it toward her, wanting her to stay back. His voice was loud and aggressive. This is my property. You have no right to put your junk on my land. Ceci felt her heart race. Fear rushed through her body. A man shouting and waving a saw was not something she expected to see that morning. She backed away, shaking, and immediately called the police. Her voice trembled as she explained what had happened. Within minutes, the police arrived. They separated both parties and took Carol aside for questioning. Sitting in a small room, wearing his grey t-shirt, Carol looked serious and defensive. He insisted that he had done nothing wrong. He told the officers that he was only exercising his right to protect his property. He claimed he was using self-help to remove something that did not belong there. But the officers knew it wasn't that simple. Yes, the sign crossed into space. Yes, Carol had right over his property. The damages causes, the destruction of the scooter, and the fear he caused says he raised serious questions. Now, the law had to decide, was Carol defending his property, or he had just crossed the line himself.
Assalamualaikum, hi to Dr. Hanis. We are from Group 3. We'll present to you topic self-help remedies in the situation between Carol and Ceci. Let's go. So the issue is whether Carol can use self-help remedies toward destructions of Ceci's signboard made by him that involve the threat of violence to enforce his right. For the law part, self-help remedies can be defined as action taken by someone on his own initiative, the action taken to protect his right or to enforce a wrongful act. Self-help remedies are outside the jurisdiction of the judiciary, where the aggrieved party does not have to rely on court proceedings to enforce his right.
However, the law usually discourages this approach because when a person is angry or aggrieved, they tend to act on their feelings. As a result, they may fail to think rationally about the extent of the action that should be taken so as not to overstep the bounds. In the case, the individual may be involved in a tort and could find themselves sued. If this is the case, the aggrieved party would plead self-help as a defense, letting the court then assess whether the action taken was still reasonable or violated the law. Examples of self-help remedies include abatement of nuisance. If there is a nuisance, the owner or occupier of the land can take actions to stop or remove the nuisance without having to go to court. The important conditions for allowing such actions are that you must first warn or notify the neighbor before doing so, unless the situation is of grave danger and you do not enter the neighbor's land while you are removing the nuisance. For example, if the branches of neighbor's rambutan tree enter a space of your house, you can cut the branches without telling the neighbors, as long as you do not cut the branches while you are in the neighbor's land. In reducing the nuisance, the plaintiff must exercise care as not to cause unnecessary damage as a result of his own reaction. In simple terms, if there are two ways to do it, choose the safest and least damaging way.
Assalamualaikum warahmatullahi wabarakatuh. So moving on to the application. So does Khairul have a lawful right to object to Sazi's signboard enlarging 5 feet into his airspace? So we know that it is under self-help remedies which is abandonment, and the self-help remedies are only allowed only if it is reasonable, proportionate and exercised peacefully. Okay. So the arrangement was a minor and not urgent, and it does not justify immediate unilateral action. Khairul cut the supporting structure with an industrial saw instead of removing only the arranging part. So the result, entire signboard are collapsed and caused extensive damage, including Sazi delivery scooters. Damage is exceed what necessary and it is not protect his right. Khairul pointed the saw at Sazi and shot at her. It is considered as threat of violence, and self-help remedy must be exercised without any force. Use of threat of violence remove legal protection, and it must issue 24-hour notice. So it was unreasonable since legal remedy were not available at the time. So to conclude, for the application, action that Khairul had done was not amount to self-help and it was unlawful. To conclude, Khairul cannot rely on self-help remedies to justify and destroying Sazi's signboard. He had a legitimate right to object the enlargement. However, his action was disproportionate, destructive and involved of violence. Modern Malaysia court discharged unilateral self-help dispute should be resolved through judicial remedies. Conclusion, Khairul action was unlawful. He may have faced civil liability for trespass, death penalty. So basically, Khairul must need to inform the court about the self-help remedies. He cannot voluntarily just destroy and use violence to destroy the signboard, and like worse happened, the scooter also destroyed because of that. Thank you.
Let's talk about the first recent case, Shatila. So in this case, it was basically a property dispute. The defendants had bought the house earlier, but they defaulted their bank loan. Because of that, their bank auctioned the property and the plaintiff bought it. After the deed of assignment was signed, the property legally belonged to the plaintiff. But the problem was, the defendants refused to move on even when they were given notice. So the defendants tried to justify staying there, saying they were just protecting what they believed was still theirs. Basically, they relied on self-help. But the plaintiff argued that you can't just decide everything on your own like that. If there's a dispute on a property over a property, the correct way is you have to go through courts. So the High Court was very clear on this. The judge said that the amendment to the Specific Relief Act, self-help remedies on property disputes are basically discouraged. The court even used the phrase that self-help should be relegated into oblivion, meaning you cannot take law in your own hands, you have to go to court. So this is where this case, Shatila, directly connects to Khairul's case. Just like the defendants in Shatila, Khairul might feel he had a right, in his case, the signboard entering the airspace. But Shatila's case shows that having a right doesn't mean you can enforce it however you want. So instead of going to court, Khairul destroyed the signboard and even threatened Sazi, which clearly crosses the line. So based on this case, his self-action wouldn't be protected.
Assalamualaikum to Dr. Hanis. My name is Laila Adriana. My mention number is 303613. Next, I will talk about an important case regarding the limits of self-help in Malaysia. So in the case of Tuan Hairul Anwar against Azahara bin Muhammad Sharif, so the fact of this case are quite relatable in the business world. So what happened in this case was, it has a kind of dispute over a business premise. So the defendants felt their commercial interests were at risk. So instead of going to court, they decided to take matters into their own hands. They physically blocked the plaintiff from entering the premise and even removed file and documents. So they did all of this without a court order, under the pretext that they were simply protecting their business. But as we all see, the law has a very strict view on this. When the matter reached High Court, the judge was very clear. The defendant's conduct was unlawful. The court emphasized a key principle, which is parties are not entitled to act upon themselves to enforce what they perceive to be their rights. The judge noted that the moment you bypass the legal system to settle a property or commercial dispute, you are undermining the rule of law. So the court held that this kind of unilateral self-help measures disturb the balance of justice. So even if you believe you are right, you cannot simply take the law into your own hands. So what should have happened? So the court clarified that the proper remedy for a breach of right is to seek quantifiable damages or a formal injunction through a legal claim. By choosing to act forcefully instead of through the courts, the defendant moved outside the protection of the law. The big takeaway from this case is that legitimate grievances do not justify illegal actions. If you have a dispute, you must follow the process. This case served as a warning that excessive self-help will likely result in you being liable for damages regardless of how right you thought you were at that time.
Good day everyone, my name is Yashrin Ramu and my matrix number is 306972, and today I'll be presenting the facts and also the current legal standing of Shah Alam High Court suit involving Matrix Parking Solution and also the Aman Crimson Development. So in September 2023, Matrix Parking Solution and 10 other commercial owners filed this suit. The central issue of this case is an allegation of bad faith where the plaintiffs claim that the management corporation, who is the second defendant, is unfairly demanding that commercial parcel owners pay the same maintenance and sinking fund rates as residential owners despite being a mixed development. So the case hinges on two main critical questions that have been recently settled by our court of facts. First is, can the management corporation unilaterally reclassify parcels such as separating car parks from shops within the same commercial category just to charge higher fees? And the second is, does the law require maintenance charges to remain uniform unless a significant differences in the legal purpose of the units is strictly proven? So we have to see the recent judicial reason, which is the federal court ruling in 2025. So it is important to note that the federal court in November 2025 reaffirmed that the uniformity principle. In a similar landmark ruling, the court held that the charges must be uniform within the same category, and the management corporation attempt to impose different rates was declared unlawful because they failed to provide actual historical and expenditure data. And arguments based on high intensity use were dismissed as hypothetical and also arbitrary. So regarding our specific suit at the Aman Crimson, as of May 20, 2025, the developer, which is the first defendant, has withdrawn the suit, and the proceedings are strictly ongoing against the management corporation and the Land and Mines Office. Based on the recent federal court precedent I mentioned just now, our solicitors believe that we have reasonably good chances of success. While the final financial impact depends on the court assessment, the legal trend clearly favors Matrix Parking Solution against non-uniform rates, and therefore we are now heading toward a full trial expected in December 2026. And that concludes our case for now. Thank you.